recommendation could give more or could give less.
Absolutely. The recommendations of Dr. Calloway are just one piece of evidence. Granted, it would be an important piece of evidence, but it's just one piece of evidence, and the judge is always free to do what the judge chooses to do in a case like that. So the result could have been different than what Dr. Calloway had recommended.
We're asked about Laura and your billing rates and what you
Yes,
had
ma'am.
billed, and said that she had paid some $6,000 to $7,000 to you.
That's correct.
At that point, was that an issue with you going forward, and as far as her payment of you? Was that something that was holding you back from representing her, or something that you discussed with her?
No, that was not an issue at all. In fact, she had some financial help from her father in the case, so I was not concerned about getting paid.
So at any point did you tell her, I'm not going to be there at the hearing with you on August the 15th unless you come up with some more money?
No, we never had that discussion. I was not concerned about being paid. She had paid me timely when I had billed her, and she had help with that, so it was not an issue.
Thank you, that's all I have.
Anything else?
So under the 223 schedule, there would be 3 exchanges each week instead of 2 exchanges.
I think that would be correct, yes, sir.
Did you have any awareness that the Hayes were preparing to move to Kinston?
I had not heard, no one had told me the Hayeses were preparing to move to Kinston, no.
That would certainly make that kind of parenting schedule easier if they were living in the same town, wouldn't
It would.
it? Now, you mentioned that you weren't worried about getting paid. I mean, you were in this case. You made a general appearance. You were going to represent her. Is that correct?
That's correct.
But you would have to pay you, wouldn't you?
Yes,
Eventually.
yes, sir.
I mean, she paid $7,000 on a $10,000 bill, and there was another $7,000 coming. I mean, she would have had to come up with $10,000 eventually to pay you.
Well, at some point, yes, she would have had to pay me for whatever time.
So if that
We
hearing
would've
never
done-
happened, if the case got resolved right where it was, $7,000 she would have saved. Is that correct?
I'm not sure I understand your
I
question.
believe you testified it would cost about $7,000 more to do the contested hearing.
Yeah.
If that contested hearing never happened, she would not owe you $7,000. Is that correct?
If that hearing had never happened, no, she would not owe me for the cost of the hearing. No.
The case had settled or
Yeah.
resolved in some other way, $7,000. I mean, maybe you'd have to do a little work to clean up, but you wouldn't have to spend $7,000.
No, if the case had settled, obviously we wouldn't have to go through the expense of a trial.
No further questions.
All right, thank you. Anything else?
Did Laura Ackerson ever indicate to you that she wanted to settle and not go forward with that hearing?
She would have settled if she had gotten primary custody, I'm sure, but no, there wasn't any settlement discussions going on that I was aware of at the time.
Thank you, that's all I have.
All right, thank you, sir. Is this witness excused?
Yes, sir.
Thank you. Thank you, sir.
Thank you, Your Honor.
Call your next witness, please.
State call is Dr. Ginger Calloway.
Ma'am, there's the Bible here. If you'd remain standing, put your left hand on the Bible and raise your right hand, please. Thank you.
You solemnly swear the testimony of this court will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
You may proceed.
Thank you. Dr. Calloway, could you state your name for the jury?
My name is Ginger Calloway.
Let me, I need to give the jury some limiting instructions with regard to this testimony. Okay. Ladies and gentlemen, Ginger Calloway is not here as an expert witness. She's here as a fact witness. And as such, she's permitted to testify about her report, which I believe is State's Exhibit 406. The report itself is in evidence. The report and her testimony about it may be relevant in this trial, but only to the extent it may have been read by the victim or read by the defendant or read by both, and that it may have had some bearing on either of them or both of them that caused them to form impressions about the upcoming August 15th custody dispute. Therefore, this information should be considered only to the extent that you find it is relevant and it bears upon the state of mind of Grant Hayes or of Laura Ackerson or of both of them on or about July 13th of 2011. Otherwise, you may not consider this information for any other purpose. It is not received into evidence to prove the truth or the accuracy of the matters contained in the report, but only to the extent that that report, in reviewing it, affected the mind of the victim, the alleged victim, or the defendant. And therefore, I caution you and ask you to limit your evaluation of this evidence solely for that purpose. You may proceed.
Thank you, Your Honor. Dr. Calloway.
I'm sorry? I understand. Do you request any further limiting instruction? Okay, very well. Objections overruled. You may proceed.
Thank you. Dr. Calloway, what is it that you do for a living?
I'm a psychologist.
Okay. And do you specialize in a certain area of psychology?
Yes, forensic psychology.
Okay. Now, to be a psychologist, what kind of schooling and training did you have?
I have completed a PhD and also a predoctoral and postdoctoral internships, and I'm required to engage in continuing education, a certain amount every year that's required by my licensing board.
And where do you practice?
In Raleigh.
Do you have your own practice?
I do.
And at some point in, I guess, 2010, were you called upon by the Lenore County District Court to complete a child custody evaluation?
Yes.
Can you briefly, is this something that you do routinely as part of your work as a psychologist?
Yes.
And I guess before we get to that, what does a psychologist do? What is a psychologist, if you could summarize?
Psychologists can provide treatment and diagnosis of individuals to help change their behavior, alleviate symptoms. Forensic psychologists are psychologists who are trained to work with the court system, with attorneys, in terms of providing evaluations that will address psycholegal questions. So in the case of a child custody evaluation, the question before the court would be, what are the best interests of the children with regard to parental access or custody?
So back in 2010, the Lenore County District Court called upon you to perform a child custody evaluation in this case of Grant Hayes versus Laura Ackerson.
Yes.
And how did you get that notice that you were appointed to begin evaluation?
Mr. Hayes' attorney provided me with what's called the order of appointment, and in that order of appointment it was stated that I would be the evaluator to provide that evaluation to the court.
I guess before you get that notice that you're the evaluator, does someone call you to ask you if you're free to do the appointment?
Yes, Mr. Hayes' attorney called me to ask if I was available.
And did you tell him that you were, and that's when you got this appointment?
Yes.
Okay. And you're calling you began your evaluation?
It was at the end of August 2010.
And do you have a copy of your evaluation in front
I
of you?
do.
Go Your Honor, can I retrieve State's Exhibit 406?
You may.
Approach witness.
You may.
I hand you what's been admitted into evidence to State's Exhibit 406. Is this if you could look through this, is this a copy of your evaluation?
Yes, it looks like it is, yeah.
And I guess does it appear to have some coffee stains on the front?
Yes.
Okay. And additionally, are there some writings on here and some circling?
Yeah, it looks like it. Yes, there's some, looks like sentences that are circled and stars put in certain places and comments in the margins.
Did you make those comments and circles in the margins?
No,
And the writings in there, did you do those?
no,
Okay, but other than that, is that the report that you completed?
yes,
Okay. And you have a copy of that in front of you that's a clean copy of it?
yes.
Now, with that evaluation, can you tell the jury how you go about doing a child custody evaluation? Is the first thing that you try to determine the question that's presented to you?
The first thing is to let the person know who's calling me, and most of the time that's an attorney, that I'm required by my ethical guidelines and standards to be appointed, either through a consent order or by the court. And then once I'm provided with that order of appointment, I have a three-way conversation with the attorneys to ask them for what are called referral questions. Those referral questions are the questions that they and their client have put together that they would like to have answered in the course of the evaluation.
Okay. And did you do that in this case? Did you have that three-way call with the attorneys?
Yes,
Do you recall if Mr. Sargent, who just testified, was one of the attorneys?
yes,
And who is the other attorney?
Mr. Hill.
When you had that conversation with them, do you, I guess, acquire some background information?
Yes.
And what sort of background information are you looking for?
Information about how the parents got together, how many children they have, what the ages of the children are, what the parents' concerns for the children are.
Looking at page 2 of your report, did you find out some information about the defendant's last name, Mr. Hayes' last name?
On page 2,
The report,
yes.
And was there some confusion about whether it was Hayes or Haze?
Yes.
And in your report, what were you able to discern?
That he referred to himself and spelled his name as Haze, where the court documents referred to him and spelled his name as Hayes.
Then do you go on to provide some background information about the relationship between the defendant and the victim, in this case, Laura, and sort of the children and how that all went on?
Yes.
Okay. And then is the next part that you write down these referral questions?
Yes, that's on page 3.
And one thing I forgot to ask you, when you're appointed by the court, are you the expert for the plaintiff, Laura Ackerson, or the defendant, Grant Hayes, or how are you appointed?
The appointment is to be the court's expert. So I'm not working, if you will, I'm not being hired by either the plaintiff or the defendant. I'm working as the court's expert. And in family law, it is different, for example, than compared to criminal law, where there's only one expert. So there's only one expert that the court appoints to be the court's expert in family law. That's not the case in...
Okay, so you're the court's expert. You're not for, and I think I got it backwards, the plaintiff Hayes in the civil suit or the defendant Ackerson in the civil suit.
That's correct.
Okay. Now these referral questions, what were the referral questions that you were provided?
The first one was that Mr. Hayes questioned Ms. Ackerson's mental stability and felt that she was mentally unstable. This is on page 3, if not mentally ill. He alleged that she had a generally negative impact on the children and is attempting to alienate them from him. Ms. Ackerson questioned Mr. Hayes' credibility, says he is manipulative, and says he has made numerous threats to her with regard to taking the children from her.
And looking at State's Exhibit 406 that's in front of you, the copy staying document, are there some circles on page 3 and a star on page 4 where those referral questions are located?
The circles are actually in the section on referral of case and background. That's on page 3. On page 4, yes, there are some sentences that are circled, and there is a star on the second full paragraph on page 4.
And that's State's Exhibit 406, the document that was found in Grant and Amanda Hayes' vehicle. Could you inform the jury of what sentences are circled?
Yes. On page 4, the circled sentence reads, Mr. Hill reported that he contacted Dr. Bukowski by correspondence, a letter I do not have, and was not given by Dr. Bukowski or Mr. Hill. In a consent order and with the assistance of their attorneys, the parents arrived at a resolution of this matter, and Gentle obtained his surgery.
Okay. And could you read I guess the circle includes a little bit of the sentence in front of that. Could you read the prior sentence, starting with the allegations?
The allegations about Laura's interactions with Dr. Bukowski that are contained in the motion for ex parte emergency custody were not supported by Dr. Bukowski's records nor by phone conversation with him.
Then is there a star next to the next paragraph?
Yes.
Does that paragraph deal with Grant the Fourth, the little boy, and some questions about regression, oppositionality, moodiness, and aggression?
Yes.
Also documents some things about Dr. Wins.
Yes.
Who is Dr. Wins?
She is a psychologist in Raleigh.
Okay. And why was she involved in this case?
Well, what I say here is that she was contacted as a part of this evaluation, and in a puzzling report she says she was contacted for a custody consultation regarding custody access in mid-July 2010 by Grant and Amanda.
Detail why that's puzzling?
I said this is puzzling since the order of appointment for the comprehensive child custody evaluation appointing me as evaluator was signed by the Honorable Beth Heath on June the 29th, 2010.
So to clarify, you were appointing you as a custody evaluator, and then sometime during your custody evaluation you find out that Grant and Amanda had contacted another custody evaluator to try to get her involved.
As I understand it, she was not contacted as a custody. Well, that's what was puzzling.
Okay.
Right.
You didn't know why she was contacted.
That's
when you were
correct.
a custody evaluator.
Correct.
And that paragraph has a star next to it.
Yes.
In the prior paragraph, I should ask, Dr. Bukowski, based on your inquiry and evaluation of these parties, did you find out who Dr. Bukowski was?
He was the physician who provided the surgery to Gentle.
Do this custody evaluation after you get the referral questions. Those are the questions that are presented by each party through their attorney that you're trying to evaluate and figure out so that you can provide an opinion on what's in the best interest of the child.
Yes.
Okay. So after you do the referral questions, do you go through and come up with a history of the family?
Yes.
Okay, and that's all the information that pertains to the relationship between the mother and father and the kids?
Yes.
And in this case, the mother and father being Grant Hayes and Laura Ackerson, and the two little boys being Grant the Fourth and Gentle Hayes?
Yes.
Okay. And then do you go on to go into a process of evaluation?
Yes.
And before we get there, just looking at that part 3 that's a history of the family that you put together, is that a spreadsheet that you put together?
Yes.
Or a table, I guess?
Table.
And does it have a date, an event, and then a comment from the father and a comment from the mother?
Correct.
And why do you put those comments from each party in there?
As a part of what my role is in conducting a child custody evaluation, I would consider both what the mother said and what the father said. So they might have different interpretations of a particular event. So I put that into the timeline for the reader to see the difference.
On page 5, where that history of the family starts, before that, is there some writing in the margin that appears to say Laura called her?
That appears before the history, the table starts, yes.
And then with the history and where the table starts, is there a part, are there writings all over this table?
Yes.
Okay, and does one of those writings read, not alleged, I have proof?
Yes, on page 6.
And on page 6, is there another part that's crossed out, and next to it it says the letters BS?
Yes.
Another circled part that has the letters no written next to it?
Yes,
The word no, I guess.
that's correct.
And there's some other writings on that page.
Yes, there are.
On page 9 in that table, is there some circled language and next to it written never?
Yes, that's correct.
I guess so we don't cut anything out. To go back to where page 6 where it says not alleged, I have proof. Could you read what the event is that's next to that not alleged, I have proof writing?
807, pregnancy with Grant the Fourth, return to Greenville is the event. And where it says not alleged, I have proof, Grant alleges Laura was chatting online with other guys while he was out of town working. He set up a secret email and forwarded her emails to it.
Okay. And the next line where there's language crossed out that says BS, is that the language is crossed out, so they say living in Raleigh with various friends, and that's what's crossed out?
Yes.
Okay. And moving down the page, under the column on May 2nd of 2008 where it says Grant the Fourth born, is Laura reports she went to the Virgin Islands for a week. Is that circled and written no?
Yes, that's correct.
Moving on July 5th of 2010, could you read what that event was?
July 5th of 2010, Amanda and Grant moved to Raleigh.
Say Grant, Amanda, and Shay have first visit with Dr. Wins. Dr. Wins reports she was providing, quote, custody consultation, was not informed about impending child custody evaluation.
Yes, I'm sorry, I read the wrong thing.
Okay. And can you indicate, is Shay's name circled and next to it written never?
Yes.
And then is custody consultation was not informed about impending child custody evaluation, is that circled as well?
Yes.
Okay. After this table, is there a summary of the table?
Yes.
Okay. Is there a line underlined
Yes.
and a star next to it?
Yes.
And could you read that line?
The children resided mostly with Laura until the time Grant the Fourth went to New York City with Grant and remained there.
And the next section, is that the process of evaluation?
Yes.
And could you tell this jury about the process through which you evaluate a child custody action?
Yes. After the three-way conversation with the attorneys, then I have a meeting with the two parents jointly in my office. And I go over background information, ask them for their concerns generally, and try to get some sense of their interaction with each other. After that, I begin the process of doing psychological assessment. So the parents are given a number of psychological measures, psychological testing in other words. They're also given a number of forms to complete, both on themselves as well as on the children. They're asked to fill out a parenting history survey, which gives me a lot of information about them. And then I typically make home visits to the parents' homes to observe the parent and the children together. I also conduct behavioral observations that are videotaped between each parent and each child. And when it's appropriate, when the child is able to talk and have some interaction with me, then I bring the child or children into my office. And those are the measures and the kind of checklist and forms that the parents are given to complete.
And do you also talk to collateral sources, other people that are involved in this situation that aren't the parties, aren't Grant Hayes or Laura Ackerson?
Yes.
Okay. And how long did you spend with the defendant, Grant Hayes, in talking to him and observing him?
Roughly 20 to 25 hours.
How long did you spend with the victim in this case, Laura Ackerson?
Roughly the same amount of time.
He mentioned some observations of the children with the parents. Could you talk a little, where do you go to conduct that evaluation?
Well, when it's young children, meaning under the age of 5, I go over to the UNC Childhood Trauma and Maltreatment team, and they're kind enough to let me use their videotaping equipment, and I observe the parents and videotape them there.
Okay. And when you say you observe the parents, what interaction are you observing with the parents?
With young children, again, under the age of 5, there are some, I guess you could call them time-honored sorts of procedures that are used that are the same for each parent and each child, so that we get some kind of consistency in the way in which we as psychologists look at children and parents. So I videotape them with a specific procedure. The parents are given the instructions about the procedure ahead of time. They're written so that the child is not listening to what's being said, and then the procedure is conducted the same each time.
And just generally, that procedure, you're videotaping the parent's interaction with the child. And can you just briefly detail what the procedure is?
With young children, we want to know how children do when their parents leave the room and come back. And so the parents are in the room playing with the child for a period of time. This is in a playroom, which has child-friendly equipment. And then a stranger goes in, and this is someone who's not known to the child, sits and talks with the parent and the child for about 2 minutes, and then there's a knock on the two-way mirror, and the parent comes out, and we observe what happens with the parent's departure. And then when the parent comes back in after roughly 2 to 5 minutes, we observe what happens on the reunion phase, it's called. After that, the stranger leaves, and the parent and the child play together for a period of time. Another knock comes on the mirror, and the parent then leaves, and we observe what happens to the child when the parent is no longer in the room. And we see what the kiddo does, and after the parent comes back in, we see how the child reacts to that reunion.
And that's something that you rely on to help make these recommendations and observations and analysis of the parenting in this case?
It's a part of the entire data set.
Okay. And within that data set, I guess, looking at your dates of evaluation services and time on page 13, do you list out all the collateral sources, the people that you talk to?
Yes.
And are there and other people aside from the parties that you spoke with?
Yes.
Okay. And documents reviewed, do those include the court filings in the case?
Yes.
They include records from pediatricians.
Yes.
In this case, did you look at court orders? There's also a list that you looked at police reports from the Raleigh Police Department, Kinston Police Department about a complaint of misdemeanor child abuse.
Yes.
And who alleged that abuse?
It says here, complaint of misdemeanor child abuse from Grant regarding Laura's treatment of the children.
And did you ever have occasion to look into those reports?
Yes.
And did you determine if those were substantiated?
Um,
And turning your attention to page 13, do you document in your report that after the second contact with Mr. Rayfield, who apparently is from CPS, it was known that CPS completed its investigation without a substantiation of abuse?
yes, that's correct. That's what it says.
And what is CPS?
Child Protective Services.
Going back to page 15 of all these documents that were reviewed, did you also look at a letter from Child Protective Services closing the case, did not substantiate misdemeanor child abuse?
Yes.
Did you look at some emails forwarded from Heidi Schumacher, session notes from Dr. Wins,
Yes.
session notes from Dr. Starrett in Dr. Wins' office?
Yes.
And then did you list out the tests and procedures that you did with the children, Grant the Fourth and Gentle?
Yes.
You make some behavioral observations and observations of the home visits that you conducted with both the defendant, Grant Hayes, and Laura Ackerson.
I did.
In a home visit, what are you looking for as a custody evaluator?
Several things. One, the condition of the home. You're looking to see how child-friendly the home is, how safe it is, what kind of interactions the child and the parent have while you're there, the neighborhood that the home is located in, I said the interactions of the parent and the child, what the children's rooms look like, how they're furnished, as many details as you can possibly obtain from observing the home.
In this report, did you note any significant problems with either the home of Laura Ackerson or the home of Grant Hayes?
I didn't notice any problems with Laura's home. I did notice that there was a screen out in the children's room in Grant's home.
Okay. Aside from that, though, neither house had bug infestations or anything that looked like that the children couldn't stay there. There were things that were easily fixable.
Yes.
Okay. The screen in Grant's house, did you mention that to him to get it fixed?
I mentioned it in the report.
Okay. Now, in the home visits, did you also document the how the children behaved in interaction with the parents?
Yes.
And with Laura, did you note that the children were well behaved, sweet, and low key during the visit? Looking at page 17, the third paragraph.
Yes.
Go on to talk about how Laura didn't allow little Grant to be aggressive towards his brother and frequently encouraged him to use his words.
Yes.
And you know things like she provided healthy, tasty snacks for the children.
Yes.
Okay. And did Laura drive you to the daycare that was owned by Grant's parents?
Yes.
And you also conducted a home visit with Grant and Amanda's home?
Yes.
And you note here that that occurred after Judge Heath ordered the parents to continue with the child custody evaluation and pay the fees. Could you, I guess, summarize in the report your findings with a delay in finishing this report?
Yes, there was a delay that in November, I believe, I had requested additional funding. This was November of 2010. And when that was not forthcoming, then I notified the attorneys that the evaluation would be suspended until the fees were paid.
How much was the child custody evaluation in total?
Mr. Hayes paid me $12,500 and Ms. Ackerson paid $2,500.
And is that because Mr. Hayes paid the upfront costs?
Yes.
Okay. And then there were some additional costs that was incurred where you had to, you needed more funding to be able to complete the study?
Yes.
And how is that delineated to each party?
I'm not sure if I understand that.
How much was the additional cost that came up in November of 2010?
Maybe I need to answer it this way. The first payment came in August. That was $5,000. An additional payment came in September, I believe, possibly October, I'm not sure, for an additional $5,000. And then when the next request was made in November, that's when the fees were not forthcoming.
That request in November, how much was that for, if you recall?
I think probably $5,000.
Was that split amongst the parties? So Laura had to pay $2,500 and Grant had to pay $2,500?
The judge ordered, yes, that happened. Mhm.
Moving on, during the home visit with Grant and Amanda's home, did you note that that you found out that the boys played with toy cars and would slam them into each other's legs, I guess, resulting in bruising on their legs?
Yes.
Was that the allegation of child abuse, that there was bruising on the little boy's legs?
Yes.
The next section in this report is at the video taped observations where you talk about the attachment relationships.
Yes.
Is that what you use as videotaped observations of each parent with the child leaving and coming back?
Yes.
That section is a couple of pages where you detail the interaction of the little boys with seeing their mother leave the room. Is that correct?
Well, it details how each child acted when their mother left the room, and then also when I videotaped their father, how they reacted when their father left the room, as well as the reunion.
If you can, could you summarize the differences that you observed?
Let's see. Okay, I started with the videotaped observation of Gentle with each parent on page 21. Gentle, if I remember correctly, let me just look at this. Right. That day he was asleep when they first came to the facility, so we took Grant first. So he woke up during the time that Grant the fourth was being videotaped, and he screamed very loudly. He was with Heidi Schumacher in the waiting room. And so when he first came in to the room with Laura, he was uncomfortable, would be one way to talk about him. So when she left the room the first time with the stranger there in the room with him, this is on page 22, he seemed unsure of what to do, and so he went to the door and stood there with his head resting against the door. Then he started to wail, is the way I described it, and couldn't be comforted by the stranger. So we pretty much, when a child reaches that sort of point, we bring the stranger back in, the mom back in, or the parent back in.
And why do you do that?
Well, in doing this procedure, we want to mildly stress the child, but we don't want to overly stress them. So for a child to begin wailing in the way that he did, we wouldn't want him to be that upset. So we'd bring the mother back in, and that's what we did, so that she could comfort him.
And did you make some conclusions about the relationship, I guess, between Laura and Gentle at that point?
I believe I talked about the fact that he, was unsure of himself, and then I tried to explain that some of his behavior may be understood in the fact that she had just picked him up that morning. He hadn't seen her in quite some time, and that could have been a factor that affected his behavior that particular day. I also noted her, what we call attunement to him, in comforting him. So yes, I talked about that.
With Grant the fourth, did you conduct that same, I guess you did that one first.
Yes.
You conducted that same interaction where the parent leaves the room and you observe how the child reacts?
Yes.
Okay. And if you could, and this is, everything that you talked about is in your report.
Yes.
And that report that states 406 that was found in the defendant's car.
Yes.
Okay. What did you notice about Laura's interaction with little Grant?
Again, she was very attuned. That's a specific word in the attachment literature, but it does mean that she was paying attention to him and was sort of going with what he wanted to do in terms of playing in the room. He was verbal, so he was able to talk with her, and she interacted with him very appropriately. And so what he did when she left the room was to keep asking, "Where's Mommy? Where's Mommy?" So he was able to remain in the room without crying, but he clearly wanted to know where his mother was. And once she came into the room, then he went, "Oh, there's Mommy." So he was very much aware of her coming and going, could note it to himself, and then was clearly pleased when she came back into the room.
You say clearly pleased on page 25. Did you know that he made satisfied noises with big sighs of pleasure or relief when she came back in the room?
Yes.
And when Laura left her son, did you notice that he was somewhat alarmed and looked around the room and began making piercing sounds of distress?
Yes, that was kind of interesting. How he started off kind of, softly at first, but kept building up and ultimately screaming. He didn't sound upset. He just sounded like he was trying to get her to come back.
Now, did you also study the defendant, Grant Hayes, with Grant IV?
Yes,
And this is in your report that was found in the defendant's car?
that's correct.
And I guess at the bottom of page 27 that when Grant re-entered the room, Grant IV showed little reaction to his father.
Yes.
What else did you note about Grant IV's reaction and interaction with his father, the defendant Grant Hayes?
He didn't have very much reaction. The stranger left, and then Grant IV continued to play with the two cars, then looked toward the blocks which his father was moving about. For the first time in the 10 to 12 minutes that elapsed during this observation, Grant IV used a complete sentence and said, "Put some more, Daddy." Grant said, "More what?" And Grant IV said with emphasis, "More blocks."
How did Gentle, what observations did you make about Gentle with his father?
Let me find that. They started their session off in a playful manner with Dad, that would mean Mr. Hayes, imitating Gentle in his smiling and shaking his head. In some ways, Mr. Hayes seemed somewhat uncomfortable and related to Gentle with words and directions that were more easily understood by a child older than Gentle. Gentle was content to play with the toys and explore the room with very little interaction with Dad. When Dad called his name, he ignored him. When Dad called him to look at this toy or that toy, he looked at the toy, picked it up, and carried it to another part of the room, exploring on his own the borders of the room and various objects in it. His main interaction with his father happened with a toy frog that held candy. When the stranger came into the room, then Gentle moved toward his dad and sat at his feet. And when Dad, when Dad left the, I'm sorry, did you?
No,
Okay. When Dad left the room, leaving Gentle with the stranger, Gentle was clearly upset and cried. When Dad re-entered the room, neither he or Gentle had a reunion, and instead Mr. Hayes, moved Gentle immediately to toys or to distraction. And here I referenced a graphic that I use later to talk about this. Grant did not adhere to the directions for the strange situation. This is what this procedure is called, completely, which makes the interpretation of resulting behaviors less than standard. On returning this first time, Dad was not immediately comforting to Gentle, although he did respond appropriately and in a comforting way once the stranger left the room. He did this when he bounced Gentle on his body, brought Gentle into his physical space for comforting, verbalized, "You all right?" When Dad left the room, leaving Gentle alone, then Gentle clearly and immediately indicated his distress when Dad prepared to leave. His face screwed up in preparation of crying. He started whimpering, and he looked at Dad as if to say, "Don't leave." After Dad left, Gentle cried loudly, walked toward the door through which Dad had just departed, looked back at the toys several times, grew quiet, and continued to stand near the door and whimper. Once Grant came back in, the stranger came back in because he was somewhat upset, and he was temporarily soothed, but then he walked to the door whimpering and kicking a toy that the stranger tried to use to engage his interest. And then when Dad came back into the room, at that point, Gentle attempted to leave.
Okay. And this is all documented in your report.
Yes.
Moving on, you do some parent interviews and you list rating scales, records, and parent interviews. That's the next section of your report.
Yes.
And what is the purpose of that section?
Well, you want to see how well the parent knows their child, what they can tell you about their child in the interviews. You want to find out the kind of details that the parent knows about their child.
Okay. And how do you get those? Is it solely from the interview? You mentioned earlier there's a parenting history survey. What is that?
The parenting history survey is a lengthy survey that asks a number of questions of the parents to fill out with regard to demographic sorts of data, and then also with the legal history that they've had, to give some background about themselves, to give details about the children, to talk about what they want for custody or parental access, to tell something about their concerns about the other parent, what they think the other parent might say about them. It's a fairly detailed sort of form.
And the ratings, do you use rating scales? I'm looking at page 29 of your report. There's a child behavior checklist and the ages and stages questionnaire, attachment caregiving scale. These are all, I guess, tools that you use to evaluate the custody situation.
Yes, and then there's another infant and toddler family instrument that is a very detailed sort of interview that I conduct of the parents, and I give them a developmental history form. And so during those interviews, I get detailed information about the parents' perception of the child and what they're like.
In this, on this page 29 of this section, do you know that both parents feel attached to Grant the Fourth? I'm looking at the third paragraph, I guess about halfway through.
Which paragraph? I'm sorry.
The third paragraph.
All right.
It starts on the various rating scales. Is there a sentence in there that says both parents feel attached to Grant
Yes.
the Fourth?
Mm-hmm.
Could you read the next two sentences?
Yes, both parents feel attached to Grant IV, although Laura describes specific ways in which she noted the attachment developed. Grant's descriptions were more general, and he seemed confused in that he described his own attachment to his father rather than his child's attachment to him.
Moving on in that paragraph, do you talk about the written comments of Laura?
Yes.
And what does that say?
In her written comments, Laura was mostly concerned with Grant's aggressiveness toward her and Gentle, meaning Grant IV.
We're talking about the little boy.
The little boy,
Grant
yes.
the Fourth, Laura was concerned was aggressive towards his mother and to his little brother.
Correct,
Okay.
yes. And to Gentle, his use of profanity, meaning the young child, the 3-year-old, his profanity and the fact that he calls himself a bad boy.
And what did the defendant, Grant Hayes, report?
Grant reported that Grant IV's anger expressed after phone calls with Laura as a concern.
Moving on, do you list some biographical and background information about little Grant and little Gentle?
Yes, their birth history.
Okay. On the next page, on page 30, do you note some significance with Gentle's development history?
Yes.
And looking at that middle paragraph, what do you note?
That he had some difficulty sleeping at night, and that I put here how Laura described him and also how Grant described him.
You also note that of significance is Gentle's development history is the fact that he had very limited contact with his father from birth to age 10 months.
Yes,
And again, this is all in the report that's found in the defendant's car.
yes.
Okay. On the next page, did you talk to some collateral sources about information that had been given to them about these children?
Yes.
And then the next sections are those evaluations of the father, Grant Hayes III.
Yes.
And do you use a variety of different tools and testing and psychological testing to evaluate each parent?
Yes.
On the top of page 34, that paragraph, could you read that paragraph?
Grant was extremely negative
Just to be clear, we're talking about Grant Hayes III, the defendant.
Yes, this is the section of the report that details the specific findings from psychological testing.
And what did you note?
Grant was extremely negative, at times paranoid with regard to Laura, her character, and her alleged actions. It was confusing why he repeatedly sought to tell others, in addition to me, about Laura's alleged sexually transmitted diseases and her internet activity with other men, which he characterizes as prostitution. He told the court by way of the motion for ex parte emergency temporary custody. He told Child Protective Services. He made mention of his perceptions about her sexual behavior to Dr. Bukowski and to the Raleigh Police Department. His rambling and tangential thinking included excessive, negative commentary about Laura and repetition of several events involving her alleged depravity within developmental history forms and other child-specific interviews asking for specific information about the children. He represented to doctors' offices and others that he has full legal custody when that is not wholly accurate. Dr. Wins was uncomfortable with the anger and rage he expressed verbally with one or more children present in her office. His anger toward Laura and these various actions where he is not wholly appropriate with regard to characterizations of her make him appear to have a determined agenda.
Moving on to page 37, the second paragraph. Did you write in this report that's found in the defendant's car that Grant reports that his 4-year relationship with Laura started when they met at a bar and she asked him to give her guitar lessons?
Yes.
I think you read the next sentences.
They thought they were destined for each other because they have the same birthday.
Did he go on, or did you note in your report that he says every day with Laura was negative and he described her as controlling, manipulative, and underhanded?
Yes.
The accuser flip-flopping on stories.
Yes.
He alleged that she threatened to abuse the children if he would not reestablish his relationship with her.
Yes.
Going on in there to talk about his allegations that she was an online prostitute, and he says he read about internet sting operations and interstate prostitution rings.
Yes.
Note in here, he read about people getting prosecuted, he says, and he was worried about his bank account being used. He never heard back from the FBI.
Yes.
And you give the defendant some tests. And those are noted under test results, impressions, and conclusions.
Yes.
Additionally, did you do the same evaluation and same test with Laura?
Yes.
And you got a social history and background of Laura?
Yes.
And test results, impressions, and conclusions?
Yes.
And looking at the second paragraph of the test results, impressions, and conclusions that you note in your report, did you note that Laura's mental stability and mental health are of concern to Grant and his prior attorney, Mr. Hill?
Yes.
And that Grant and Amanda are convinced that Laura is sick, poisons the children's minds, and has some form of mental illness?
Yes.
Summarizing your report, did you note that Laura had any mental illness?
I noted that she did not.
Did you note that she was sick or poisoned the children's minds?
No, I found no support for that.
Did you also talk to collateral sources and folks like the pediatric urologist, I guess, who was to perform the surgery, Amanda Hayes, Dr. Wins, this other psychologist, Heidi, some other folks?
Yes.
Okay. And then on page 47, is that where your analysis begins?
Yes.
And this analysis was What is the purpose of this analysis?
To integrate all the information that I obtained in the course of the evaluation.
And if you could, that analysis, could you just read what's in your report that was found in the defendant's car, the first couple sentences of that first paragraph?
There are several areas that are highly significant with regard to findings from this evaluation that are necessary for the court to have. These include the disruption of the children's relationship with their primary caregiver, their mother, an understanding of the parents' separate pathology, the chaotic and destructive nature of their relationship, and the specific nature of their conflict.
And if you could continue to read that entire paragraph.
All right. Grant's misinterpretations that are passed on as wholly accurate and factual to authority figures who can pass judgment on Laura, and Laura's underdevelopment that causes her to become overwhelmed rather easily are significant findings. It is critical that the court be informed regarding the insensitivity of Grant, Amanda, and the paternal grandparents regarding the children's deep need for an unalterable bond with Laura. Related to this is the expressed desire of Grant and Amanda to leave the area, to travel, and to take the children with them, and Grant's stated opinion that he should have total control through legal and physical custody of the children, with supervised visitation only for Laura. Of utmost importance is the need for repair in the children's relationships with both parents, the requirement that both parents be fully involved and thus present physically for that repair and the young ages of the children.
I don't want to interpret that, but in your analysis, to summarize, this report's 59 pages, is that correct?
Yes.
Okay. To summarize, it's important for children to have a good relationship with both parents, correct?
All other things being equal, yes.
Okay. And in that paragraph, you're writing about the I don't want to put any interpretation on this, but that Grant and Laura both need to have a role in the kids' lives.
That's correct.
And what you mentioned about the traveling and taking the kids with them, that would rob the kids of having a relationship with their mother.
Correct.
And that's in this report that's in the defendant's car.
That's correct.
The third paragraph, could you just read the first two sentences of that?
Starting with the most significant finding. The most significant finding to emerge from this evaluation is the disruption to the children's relationship with their primary caregiver, their mother. For a variety of reasons, both children spent the majority of their time with their mother during the critical age periods for attachment formation or from birth to 18 months of age. This should not be interpreted to mean that their father was unimportant or insignificant, only that, quote, for hundreds of thousands of times, end quotes, during these months, Laura was primarily the individual immediately available to soothe the children when they cried, to rock them or otherwise assist them to sleep, and the parent most immediately available to meet needs related to hunger, discomfort, wet, dirty, upset, pain, pleasure, joy, delight, and competence.
And then the next couple of paragraphs talk about these phases of separations when children are separated from their parents.
Yes.
Okay. And then on the bottom of page 48, the first sentence of that last paragraph, could you read that to this jury?
When taken to New York City in February of 2010, Grant IV was abruptly separated from his mother, his primary caregiver, at 21 months of age.
And do you go on to describe how Grant IV had some issues related to being separated from his mother for these months?
Yes.
Okay. And then do you talk about how when routine visitation returned, the effects it had on Grant IV's feelings of loss for Laura?
Yes.
Okay. Now, on the bottom of page 49, do you talk about Gentle and how, if you read the first sentence there?
Gentle, who was nursing at the time, was abruptly removed from Laura's care at roughly 10 months of age. About 2 weeks after the...
If you could just keep reading the next couple sentences.
About 2 weeks after the transition to Grant's home, Gentle underwent surgery. The importance to Gentle of his father's absence as a routine caregiver from roughly 2 months of age to roughly 10 months of age is critical in terms of attachment relationships and in terms of his transition to his father's home.
And could you read the next two sentences?
His father simply was not present for the attachment process to occur. Hence, he was a virtual stranger to Gentle, and therefore not someone Gentle could rely on when he was transitioned to Grant, Amanda, and Shay.
And moving on through these next couple of pages, are you analyzing the relationship of the parents with the children and how this custody dispute was affecting the children?
Yes.
Okay. And on page 51 in the second paragraph, you note that the two parents are greatly polarized.
Yes.
And the paragraph before that, do you talk about, in addition to the disruptions of children's experience, it should be noted that the current schedule of parenting access time is wholly inappropriate for the children, considering the ages of the children?
Yes.
And if you could just summarize, I know I'm asking you to summarize a 59-page report, but why was that wholly inappropriate?
These were young children, and young children fare better with parenting access plans that are sometimes called custody access plans when there's no more than 3 days of separation from either parent.
And then the next paragraph details some problems that Laura had. Do you state that Laura was insecure and unsure?
Yes.
And that's in regard to dealing with Dr. Bukowski and trying to schedule Gentle surgery?
Yes.
Do you also note that, I guess the last 3 sentences, she's quite hindered and impacted by her extreme anxiety and underdevelopment?
Yes.
And could you read the next 2 sentences?
She also obviously has no family supports, evidenced by the fact that no family members came to her assistance when she and Grant separated and terminated their union. She may have been intimidated by Grant and was systematically isolated from others by some of his actions.
Could you read the first sentence of the next paragraph?
Although Grant portrayed her as a flight risk in the ex parte motion for temporary custody, she had many opportunities to flee and did not.
And then the next paragraph, you talk about Grant and how he has a charming way of engaging and interacting with others.
Yes.
And you noted here that, well, Dr. Bukowski also noted that Grant's need to promote himself by reference to the famous musicians with whom he has repeatedly played.
Yes.
The next couple pages, do you note sort of the effects of these collateral sources on your analysis of what's going on with the children and their detachment and reattachment?
Yes, I provided their comments.
Looking at the bottom of page 52, do you note that both parents are very self-absorbed and quite self-focused?
Yes.
State that both have personal histories that are chaotic and both have significant pathology.
Yes.
That Grant routinely explained Laura's various behaviors regarding pursuit of him and her sense of betrayal by him as her fascination with his, quote, attractiveness and being sought after.
Yes.
You know, later in the paragraph, both have had a very difficult time with interpersonal relations, including their own relationship, which was volatile and destructive.
Yes.
Looking on the next page, at the bottom of page 53, could you read the first sentence of that bottom paragraph?
It is concerning when Grant goes on the attack against Laura and portrays her in a highly negative, morally depraved ways. Did you want me to keep reading?
If you could read the next sentence.
His upbringing in what he describes as a fundamentalist family where guilt was used freely for control is one likely source of his outrage at Laura.
Now, at the end of that paragraph, looking at the top of page 54, I guess the bottom of page 53, is there a sentence that starts, he also fails to understand? Bottom of page 53, like the last sentence. Sorry.
beginning with at the same time. It is particularly disturbing.
Yeah, if you could read the next sentence.
Okay. He also fails to understand the impact to his children of his angry rantings about Laura when he rages angrily about Laura in front of the children, as reported by Dr. Wins. This is very worrisome for parenting and for what he is willing to communicate to the children.
Continue with that last sentence in the next paragraph.
It is concerning that his intense rage toward and about Laura may serve as an anchor for his disturbed thinking. Grant and Amanda were unequivocal about wanting to leave the area, while at the same time they said they planned to buy a house in Raleigh. Both have said repeatedly that they want to travel out of the country and to far-flung places like Hawaii, Europe, Sweden, India, or China. Grant says he would like to get a boat and sail to Greece and, quote, live before I get too old. I want my kids to be citizens of the world and not just the U.S., end of quotes. Amanda reports they wanted to move to Nashville, Tennessee, because Grant is a, quote, songwriter. He has 700 to 800 songs. As a family, it's important for us to travel with him. Wouldn't be fair to the boys if me and the baby get to travel and they don't, end of quotes. With these kind of expressed wishes by Grant and Amanda to move away, it is obvious they do not want Laura included in the children's lives. This is very concerning because, in essence, they want to obliterate her. It is concerning because the children obviously are attached to Laura, have a meaningful and significant relationship with her, look to her for comfort, and had her as their primary attachment figure or primary caregiver for an important, critical period of their lives as infants and toddlers.
And could you read the next two sentences?
In the first joint session with Laura, Grant stated he and Amanda want full custody and believe Laura should have supervised visitation only. Laura, on the other hand, stated she thought both parents needed to be involved with the children in a parenting access plan.
So that page, at page 54, you state, it is obvious they do not want Laura included in their children's lives. This is very concerning because, in essence, they want to obliterate her. That's in State's Exhibit 406, which is found in the defendant's car.
Correct.
The end of page 54, do you note some concern?
That the bruises were consistent with injuries for children this age. These bruises were not brought to my attention by Grant, despite the fact that the parents are told in the first session with them and in subsequent sessions that if I am aware of possible child abuse, I am obligated to report suspicion of abuse. The social worker for Child Protective Services was puzzled as to why Grant would tell him about Laura's alleged sexually transmitted diseases when there is no jurisdiction for Child Protective Services with regard to this. Grant submitted a motion for ex parte emergency temporary custody, which has not been fully vetted and which may not thoroughly or accurately present all the facts. He told doctors, police, and Child Protective Service workers that he has full custody of the children, which is misleading, not wholly representative of the temporary custody order, and creates the impression that Laura is an unfit mother. He took the children to Raleigh Pediatrics and represented that the children were not up to date on their immunizations, which could have had negative results for the children since it is not wholly true. He has not informed Laura when he has left the country, as for example when he recently went to Hawaii for, quote, gigs, end of quotes, there. It is not known exactly how much actual parenting time Grant spends with the children versus the time Amanda and her daughter provide.
At the end of all this analysis, do you make some recommendations?
Yes.
And the first recommendation is that it's recommended that the parents share legal and physical custody.
Yes.
And do you list a 2-2-3 schedule of parenting access?
Yes.
And that's parent A gets a kid for 2 nights, parent B gets a kid for 2 nights, and then parent A gets kids for the next 3 nights?
Correct.
And based on your, I guess, experience in this field, is that the best way to share custody?
Yes, for these children, yes.
Do you also recommend that a guardian ad litem attorney for the children be appointed?
Yes.
And that to look out for the children's welfare in this custody dispute?
Yes.
And then the next recommendation is that at any time and no later than 6 months after the implementation of the 2-2-3 schedule, it is recommended that the guardian ad litem for the children consult with a therapist to determine the need for ongoing children for the kids in treatment with either or both parents.
Yes.
And what do you mean by that? If you could explain that recommendation to the jury.
Earlier, I read into the record about the need for repair with the children's relationships with the parents, and this was to address that.
Okay. The next recommendation is that for Grant the Fourth to start a preschool or nursery school as soon as possible.
Yes.
The next one is it advisable that both children enter into preschool programs that will stimulate their latent abilities and compensate for any parental deficiencies exhibited by both parents.
Correct.
And then do you make a recommendation about what Laura needs to do?
Yes.
And is that a recommendation that Laura needs to obtain a coach or a super parent to serve as a sounding board?
Yes.
And why was that, according to your report? Why did she need to? There's a whole paragraph about it, but if you could you just summarize that to the jury?
Right. To help her with her insecurity, to help her with her anxiety. I noted here to help her with her sense of inadequacy, to help her learn how to develop social networks, to help her with some training in assertiveness.
So a coach or a super parent, could that be someone like a mentor or somebody she knows through church?
Yes, that could be.
Somebody who's had children before?
Yes.
Did you also recommend that the defendant, Grant Hayes, obtain a parent coach in many of the same ways?
Yes, although his was more specific. It says here, parent coach specifically trained in attachment theory, on attachment relationships, and how to provide a greater sense of reassurance and comfort to his children.
I think we kind of skipped over that, but if you could you summarize the section of this report? Was there some dispute between Laura and the defendant over saying goodbye to the kids and being too attached? Or they have different parenting views on how to interact with the children?
Yes, they had different views.
And I don't want to put words in your mouth. They had different views. Could you explain your report, that portion? Could you summarize it to the jury?
I'm not quite sure how to answer that. That's a big ball of wax.
The whole point of the evaluation, I guess. Specifically looking at Grant obtaining a parenting coach.
Yes.
That recommendation.
Yes.
What did you want a parenting coach to work on with the defendant, Grant Hayes?
Okay. The things here is that I mentioned are that he interacts in a playful manner with his children. That's in that paragraph about the coach. But he lacked an understanding of the specifics with regard to what children are like at different developmental points. And he also didn't have a clear understanding of why the children were relating to Laura in the way that they were, which had to do with their separation from her. That was detailed earlier in the report.
Okay.
Yeah, so it was those sorts of things.
So these things that the defendant need to work on, these deficiencies that would be helped with a parent coach, those are all in this report that State's Exhibit 4 says?
Yes.
Now, there's a couple other recommendations. Read the first, so I don't misstate it, could you read the first sentence of the next recommendation?
Are we on page 59 now?
Yes, ma'am.
It is recommended that Grant be referred to a psychiatrist for evaluation regarding the question of a mood disorder or other possible explanations for the illogical, disturbed thinking he exhibits.
next recommendation you suggest random unannounced drug screens for both parents to make sure that the kids are safe.
Yes,
And next recommendation is for the court to retain oversight of this family indefinitely until a guardian ad litem determines they don't need any more help.
yes, that's correct.
And then do you also recommend that anyone who works with the family from this point forward be provided with a copy of this report?
Yes.
And why is that?
This is typically what I put in my report so that if there's information there that can be helpful to, like the coaches that were recommended, there are specifics in the report that talk about the strengths and limitations each parent has, and so that would be helpful to a coach.
And so this report would be provided to some mentor or coach, even the information in this report as it comes from both of these people, from all the collateral sources, from the psychological testing that you perform.
Yes.
Okay. Now, you mentioned that, I forgot to ask you about, you mentioned these parental parenting history surveys. Those are questionnaires that you give each parent,
Yes.
and are the parents to fill that out and provide any supporting evidence to help you reach this analysis and these conclusions?
Yes.
And did the defendant fill that out and supply that to you?
The defendant, you mean in the criminal matter? Okay.
Did Grant Hayes,
Okay.
the third, provide a parenting history survey to you
Yes.
where he answered all those questions?
Yes.
And those were his writings and his words on those pages?
Correct.
Okay. And did Laura also respond with a parenting history survey?
Yes.
And she typed that whole thing out?
Yes.
She also gave you a notebook?
Yes.
And what was the notebook?
The notebook had, it was tabbed into different sections, and so in the parenting history survey, she would make a comment like, let's see, something specific. She made several comments there, as well as in interviews, about Grant's drug use. So she would reference those in.
Overall, go ahead.
Notebook, I'm not sure I'm aware.
Overall.
Dr. Calloway, did you provide all the resources that Laura gave to you, to the state, to give to the defendant in discovery?
Yes.
Okay. And that includes your confidential witness?
You may. Good time for the morning break.
I think I'm ready to proceed. I can ask about something else, or if it's
Well, it's 11:30. I mean, that's why I inquired. Okay. How much longer on direct do you think it'll be?
10 minutes.
Okay. All right, folks. Why don't we take the morning break for about 15 minutes? Obviously, don't discuss the case among yourselves. Keep an open mind. Don't formally express any opinion about the guilt or innocence of the defendant or any matter in controversy. Be careful about your conduct. Follow my previous instructions.